let me just say I'm glad I had a few minutes to sit after Dean Broderick, who was Chief Justice Broderick to me, because that's where I primarily encountered him. And it's interesting to be able to be relaxed when I hear his voice and not be worried and not wonder, you know, is it going to be the first question that's a stumper and I won't even be able to say anything, or will I end with a stumper and my argument will sort of dissolve in front of me? So with that said, what I would ask you to do is think about the First Amendment that guarantees freedom of speech. Think about it in the context of the Constitution. What's its role in terms of the Constitution? And I will submit to you that there are scholars who believe that the Constitution, by dispersing power among three different but co-equal branches of government, really set up a method of governing by debate. And I think the easiest way to demonstrate this is think about Congress, Senate, House. How do they enact law? Through debate. The administration has a part of the debate, obviously, because the president has the right of veto. So the administration's got to be involved in that debate. Today, avoiding a fiscal cliff if they're successful. And then, of course, we have the Supreme Court, and that gets involved sometimes in the debate. Earlier this year, Obamacare, a 5-4 decision, a debate amongst the judges. We debate not only in Washington, but here in Concord in the Capitol, and in all the communities of New Hampshire, in all the communities in the 50 states. The debate is ongoing. If we're successful today, you're going to take that debate, some of what we talk about, back to your communities and your schools. So in adopting the First Amendment, the role is to give all of us the right to be a participant in the debate, because the First Amendment guarantees freedom of speech, freedom to peaceably assemble, and freedom to petition our government to redress grievances, all secured by the First Amendment. Now, there are 4 points with this in mind that I'd like to leave you with. The first is that our founders understood that if there is going to be debate, and debate is the way we govern ourselves, there has got to be compromise. And I can say with certainty that they knew that, because that's how the Constitution came to be in Philadelphia in 1787. They got together, they debated, they had to make trade-offs, but they ultimately came out in September with the adoption of a Constitution that then had to go before the states and the ratifying conventions. And what did John Jay, James Madison, and Alexander Hamilton do? They published what we now know today as the Federalist Papers. They participated in that debate. So compromise matters. It's fundamental to debate, to the way we govern. And we've seen, I think, both at the national level and here in New Hampshire, what happens when people are not willing to compromise. The second point I'd like to leave you with is the suggestion that words really matter. They set the tone and the substance of debate. In 1989, Václav Havel, some of you may remember a Czech writer of prominence and a dissident, was awarded a Peace Prize by the German booksellers. And his acceptance speech was titled, "A Word About Words." A wonderful piece, a very provocative piece. The key insight that I took away from reading that many, many years ago, and I was reminded of it as I prepared my remarks today, is his statement that, quote, "Words are a mysterious, ambiguous, ambivalent, and perfidious phenomenon." And he explained, and I quote, "The meaning of every word also reflects the speaker who utters it, the situation in which it is uttered, and the reason for its utterance. The self-same word can at one moment radiate great hopes, at another it can emit lethal rays. The self-same word can open up glorious horizons, at another it can lay down tracks to the entire archipelago of concentration camps." If you're interested in a very powerful piece of writing, good old Google can give it to you by Googling Havel, "A Word About Words." The point is, to me, and I hope I can convey it to you, is that in debate, every word matters, and we all should handle them with care. The third point I like to express with the idea that nobody has a monopoly on wisdom. And Adam Liptak, by reading the Souter excerpt, really sets this up very nicely. At the end of World War I, the Supreme Court issued 4 decisions that arose out of the Espionage Act, an act that criminalized writing and action that undermined the government and the government's efforts in World War I. And the 4 cases arose out of pamphlets and circulators that had been distributed that were critical of the government's role, encourage workers to strike, not manufacture munitions, and oppose the draft. And in the first 3 of them, in January of 1919, Oliver Wendell Holmes, that famous judge, wrote for the court upholding the convictions based on these circulars. 10 months later, in a case called Abrams, the court upheld the conviction, again based on circulars, and Holmes this time was in dissent. And this is where I wish I could put a slide up, but I've got it. And the key point that Holmes made is the following: "But when men have realized that time has upset many fighting faiths, they may come to believe that the ultimate good desired is better reached by free trade in ideas, that the best test of truth is the power of thought to get accepted in the competition of the market. That, at any rate, is the theory of the Constitution." Some of you may have read John Stuart Mill on liberty, and that is one of the points he makes in defending free inquiry. Justice Souter, Adam Liptak talked about, gave an address at Harvard in 2010, the Harvard Commencement Address. Some of you may have read it. It's online. It's an exquisite piece of writing. But he told 2 stories in that address about why constitutional judging is difficult. And one of them had to do with what he referred to as constitutional facts. And he used the Brown v. Board of Education case to illustrate his point. Brown v. Board of Education, as many of you will remember, was the case in 1954 where the Supreme Court ruled that discrimination in public education by separating the races violated the Equal Protection Clause. And in Brown, what the court did was to abandon a belief that the idea separate but equal treatment of the races was constitutional. It had announced that proposition some 50 years earlier in a case called Plessy. Plessy involved separating the white race from the black race in railroad cars. And the court in Plessy said that was all right. It didn't violate equal protection. And what Justice Souter said at Harvard in 2010, and I'm going to paraphrase and then I'd like to quote from him. To paraphrase him, he said, "The Plessy court remembered when slavery was the law in much of the land. To that generation, identical but separate railroad cars meant progress. But to the generation of 1954, enforced separation without the background of slavery looked much different. As a consequence, the Brown court in 1954 found a meaning in segregating the races by law that the Plessy court did not see. The meaning of facts, the differing judicial perception, turned on the experience of the judges on their ability to think a point of view different from their own." And doesn't this sound like what Adam read from the Souter excerpt? Judges, we all need time to think about things, to work things out in our own mind. In that address, Justice Souter had no occasion to remember something that I've thought about over the years because I was growing up in the early 50s. And one of the points is that you'll remember that President Truman integrated the Army during World War II. And many of you who were baseball fans will remember that Jackie Robinson in 1947 broke the color line. And that by 1954, for those of us who were old enough to be watching baseball, we could see a number of highly regarded black players on our TV in our homes. They were very much a part of our life. And that was a judicial perception that was present in 1954 that was not present back in 1896 when Plessy got decided. And I think, and I will submit to you, it is the way in which the Constitution keeps up with the times and changes over time. And Adam said it, I'll repeat it, all we have to do is look at our younger generation today to see how they are upsetting, in the words of Justice Holmes, many fighting face. And it's done over time. The fourth point and the last point that I'll leave you with, I can state very briefly. I think it's vital to meaningful debate. And that is that everybody who participates in debate should be given a fair opportunity to speak his or her piece. Because it's that opportunity which, in my view, is implied in the First Amendment, freedom of speech. It's that opportunity that makes the debate fair, because all sides have gotten heard. And it's that opportunity in governing in a democracy that makes debate fair. Thank you very much.